Welcome back. I'm Jessica Eaves Mathews, and I want to talk today about what investors look for in your intellectual property before they're willing to write a check and give you some money. So, if you are a founder who's planning to raise capital or even thinking about that down the road as a possibility, then this episode is for you. I want to walk you through exactly what investors are looking at when they examine your intellectual property during due diligence, because they do. And what they find or what they don't find will directly affect whether you get funded and how much your company is worth. When I'm talking about intellectual property, just for purposes of this, I want to define it because some people think when you say intellectual property or IP, you're only talking about patents. But intellectual property is actually a category of intangible ownership rights that include patents, but they also include trademarks and copyrights, and could include packaging, trade dress, which is the look and feel of your product, and trade secrets. IP due diligence is really a standard part of any serious funding process by investors. Investors are going to look at it to verify that the assets that they are investing in, your brand, your technology, your proprietary content, your secret sauce, whatever it is, actually belongs to your company legally and is legally protected properly and fully. It's not like a box that they're checking. It is a systematic audit that they're going to be doing, and it touches more areas in your business than you might expect. So let's first talk about trademark registrations. Investors 100% want to see that your brand name, your logo, your tagline, and any other key brand identifiers are federally registered with the USPTO. So we're not talking about the fact that you just put a little TM next to them and you are saying you have a trademark. You may have a common law trademark just because you started using it, but if you have not applied for federal registration and received it, you don't have the protection that investors are looking for. A registered trademark provides nationwide priority from the date of filing and access to federal court for enforcement of your rights and eligibility for enhanced remedies, including statutory damages. The statutory damages for trademark give you the option of, if you've been damaged, like lost profits or disgorging of profits by the defendant. And enhanced damages mean that the court is going to multiply that by some multiplier, like 2 or 3. It's an increase in the damages, and that is a result of the infringer doing it on purpose and willfully. And you may also get access to attorney's fees and costs for having had to go after the infringer. So these are all really vital rights to have. Now, if you have a pending trademark application, that's better than nothing. But a fully registered trademark is really what investors want to see. And this really matters because a registered trademark is a barrier to entry. So it means competitors cannot legally use your name or anything confusingly similar to it in your industry, in your market, with respect to goods and services that are similar to yours or related to yours. So without that federal registration, your brand recognition is really weak. It's undefended, and investors know that undefended assets can be taken and can potentially not be monetized. They certainly cannot be counted on to increase the value of your business. So it's incredibly important to get this right. I want to give you an example. There's a company called Rhode. It's Hailey Bieber's skincare brand that she launched, which was acquired by E.L.F. Beauty for $1 billion with a B in 2025. And that deal would only have worked because that brand has value, and that brand only has value because it's legally defensible. Now, you could argue that Hailey Bieber's celebrity adds value in and of itself, but she needed a federally registered trademark to really satisfy investors. And she did end up having a trademark dispute with another company called Rhode, which is a fashion brand, not a beauty brand. And they had about a 2-year fight over it that was eventually settled before E.L.F's acquisition of the company was closed. And if it had not been settled, that unresolved intellectual property trademark risk would have significantly complicated or reduced the value of that deal. Investors they price in risk, they factor it in, and unresolved trademark disputes are just about the riskiest things that they can find. That can be a real deal killer, especially if you don't also have a celebrity reputation to enhance the value of the brand separate from the trademark. The next thing you need is what we call a clean chain of title. And this is where most startups really get tripped up. And it's especially common in the fashion and beauty space, although I've seen it in a lot of different industries. But it's where an investor's legal team is going to trace the ownership of every piece of intellectual property back to its origin. And you don't want to break in that chain of ownership. For example, who designed your logo? Was there a written agreement assigning the intellectual property rights, the copyright, trademark rights, all kinds of legal rights in that intellectual property to the company at the time? Who shot your photography, to your product photography, for example? Was there an agreement with that photographer that your company owns all of the IP rights in those resulting images? Who built your website? Who created training materials or course content, etc. If any of those people were independent contractors, then and there's no written IP agreement or what's called a work for hire agreement on file or assignment on file, then the company probably does not own the rights in that work. So the chain of title does not extend to the company. Under US copyright law, a work that is created by an independent contractor belongs to the contractor, not to the company, even though the company paid for it. The only way it belongs to the company is if there's a written assignment. And so that catches founders off guard constantly. Almost every client I've ever had didn't know this. And we always have to deal with this. I deal with after the fact IP assignments all the time for my clients in order to shore up that chain of title. The founder may have hired a designer, they paid $5,000 for a logo. They paid a photographer $2,000 for product photos. They assumed that ownership transferred automatically. It did not, unless the language is in those agreements. And I have worked with founders who realized only during due diligence preparation that their logo, their website design, their product photography, significant portions of their marketing content, etc., were technically still owned by the freelancers who created them. And fixing this after the fact means tracking down those contractors. Maybe they've moved on, maybe they've changed careers, maybe they've disappeared entirely. Some will actually refuse, they will refuse to sign retroactive agreements. And some, very commonly, will demand additional compensation for the assignment of those IP rights. So every one of these conversations is vital to have. It can be very uncomfortable and it creates risk. And until you deal with this and have those rights assigned to the company, there is no ownership in those items. So you can't apply for a registered trademark in a logo that you don't own, for example. So you got to get the copyright rights settled before you can own a trademark. Another issue is that sometimes companies change form. So maybe you started with an LLC in one state, then you moved to another state and opened up another LLC and then just started using the trademark that you used with that original LLC, but you never did any type of corporate merger or assignment to the new entity. That means there's a break in the chain of title, and we've got to go back and fix that before you can claim ownership rights. And it's particularly problematic if you've already applied for trademark registration and attested to the USPTO that the company that you applied for registration in is the one that owns the rights, when in fact, maybe it isn't. Maybe it's your original LLC and you didn't do an assignment, or the designer owns the rights. So it's vital to get this stuff squared away now, because investors are going to ask these questions. Okay, third, freedom to operate is an issue. So investors want to know that your use of your brand and your content, your technology, does not infringe on anybody else's rights. So have you done clearance searches for your trademarks? Have you had a good lawyer, trademark lawyer, do that? Are there any existing disputes or threatening communications? Are you aware of a potential dispute with another trademark owner? Have you received any cease and desist letters that you may have filed away and forgotten about and just didn't respond to? Are there any pending oppositions or cancellations with the United States Patent and Trademark Office, or what's called their Trademark Trial and Appeal Board, that you failed to mention to your investor? Did you get any social media takedown notices, DMCA takedown notices? These are all the things that investor due diligence will surface, will reveal. And surprises at this stage are never good for your relationship with that investor. And it's likely going to kill the deal, because not only is it problematic that you don't actually own the rights in your IP, you didn't know to own the rights in your IP, and that reflects very poorly on you as a founder. And it's going to make the investor less likely to invest in the company, because they're going to be concerned about what other things did you not take care of and handle properly. And then the fourth issue is enforcement history. So this one surprises founders, because They assume investors only care about whether they're being sued and not whether they are suing others. But investors actually like to see that you have monitored and enforced your rights. So with trademarks, for example, if you know that there are other brands out there that are copying your mark using an identical version or something very similar in your industry and you've done nothing about it, even if you have a registered trademark, that is problematic. And actually, the failure to enforce your trademark rights can create a waiver problem where you've waived your rights and therefore you don't own the rights anymore. And then that's going to kill the deal. So enforcing your rights is just as important as the original actions taken to make sure you own them and you register them. If you've been aware of infringers and done nothing, that's going to basically be a signal to investors that you don't understand the importance of enforcement and that your brand is weaker than it appears, or maybe your rights are totally gone. They've been basically waived. So either way, it's a major red flag for investors. And then fifth, and finally, and this is one that really is going to separate sophisticated founders from everyone else, and I want you to be considered a sophisticated founder, the intellectual property's connection to the company's revenue. So investors are not interested in intellectual property just for its own sake. They want to understand how your IP drives revenue and how it creates competitive barriers, right? So that your competitors can't compete with you because of your IP rights. So can your brand be licensed for additional revenue, for example? Can it be licensed into additional product or service categories that maybe you're not currently in? Maybe you can partner with another company and have a licensing deal, and then you get a right to royalty payments. Does your proprietary methodology or content create recurring value, maybe evergreen revenue value? Is your trade secret portfolio documented and defensible? Now, are you handling your trade secrets properly is also going to be an issue in due diligence. And there are very specific rules about what you need to do as a company to guard and protect your trade secrets. And if you don't engage in those, then they will not be considered trade secrets and you're going to lose all that value. These are things I teach my clients how to do all the time. It's vital that you understand this. And do your trademarks give you pricing power? So the stronger the connection between your intellectual property and your revenue model, the more favorably investors are going to view your company and value it. So the price they are going to give you or the money they're willing to give you is going to be higher. So here's what I tell founders who are preparing for a raise or even an acquisition, because this applies to an acquisition as well. You need to treat your IP the way you treat your financials. You need to get it audited. You need to get it organized. You need to fix the gaps before investors find them. The cost of cleaning up your IP portfolio before diligence begins is a fraction of the cost of a blown deal, a reduced valuation, or the painful conversation where an investor's attorney is going to ask you why your logo is still technically owned by a freelancer that you hired 3 years ago. It's very important for you to get this done. I do IP audits all the time for clients. And what the IP audit does is it gives us a roadmap for what we need to address and fix. So look, every business is different, and obviously the specifics of each business and your situation matter. But if there's anything in today's episode that hit close to home, I want you to know that I offer a free consultation where we can sit down together and look at your specific situation and figure out exactly where you stand and what your next steps should be. So just understand in this call, there's no hard sell, there's no pressure. It's just a real conversation about your business and what you are probably going to need to protect it. And if you're looking at investors, it's vital to have this conversation now. And you can book that on my website. Very easy to access my calendar there on my contact page. I look forward to having that conversation with you, and I will see you next time.